We have the Housing Discrimination Act, which again is Century Code 14. We have whistleblower law and the Employee Relations Act. What I would say is all these laws are fairly similar. They obviously deal with different things. Some of them we actually don't have power to investigate, which is the whistleblower law. We only have the power to try to mediate or settle these complaints. We also can take them in at the department. Housing, the Human Rights Act, Public Accommodations law, credit transaction, all those we do investigate along with the wage and hour claims we get. So these are the updated Biennium statistics that I received from our department. We had 1,772 public contacts, 402 claims filed, and 410 claims closed for human rights. The reason there's more claims closed is sometimes cases carry over. Investigations can be lengthy processes. So, sometimes they carry over to the next biennium, not saying they last 2 years, but sometimes somebody files in, the month prior to the end of the biennium, and then that case carries over. Now, for housing, of those claims, we had 28 that were filed on disability. We had 6 on retaliation, public assistance had 4, familial status had 3, sex had 6, race had 8. The big thing here I would point out is disability continues to be the most common issue that we see here at the department. It also continues to be the most common issue we have with, nationally as well. What I can say is also people can file on multiple bases or bases. You can file on disability and national origin. You can file on color and age, sex and race. You could file on everything as long as you are a member of that protected category. So sometimes our case numbers, if you look at the amount of claims, doesn't quite match the number. Well, that's because people oftentimes do file on multiple bases. So for housing claims, we had 27 conciliated, 13 no reasonable cause. We also had 5 withdrawn, and that is kind of pretty common with us here at the department. Now, looking at discrimination here in North Dakota versus nationally, the trend for us these are generally our top 4 over the last few bienniums is disability, retaliation, race, and sex. The most up-to-date number I was able to find for nationally, it's disability, race, retaliation, sex, national origin, and there was a total of 15,000 cases plus in the previous annual report that they did that I was able to get the full details. Total relief combined with FAP agencies, that's what we are here at the department, is we are a FAP agency. And HUD in fiscal year 2018, there was over 18 million in relief, and in fiscal year 2019, 16 million. Discriminatory terms and conditions make up about 70% of the issues. A term and condition is something related to rental. It could be higher rent. It could be less preferred housing. If somebody comes in and they want to file on the basis of, let's say, their race, and they think that they got unfavorable terms versus somebody outside their race, and the fact that they were only shown bad apartments, that would be a term and condition of rental. But 70% of all cases filed are going to be terms and conditions nationally, and 43% is going to be reasonable accommodation. 27 to 28% would be refusal to rent. And again, you can file on multiple issues, just like you can file on multiple bases. And just because you filed on one basis, like discriminatory term and condition, you could also file on disability, reasonable accommodation. So every investigation, of course, is different. And that leads us into what is housing discrimination. Pretty straightforward, treating someone differently in the sale, rental, publication, inspection, membership, and or access to housing because of a person's membership or association with a protected category. The big thing I always point out, it's more than just a sale or rental of property. Inspections included. So when people come to visit, to look at a property, that also is a time where you could see housing discrimination occur. You could see it in financial transactions. You could also see it in credit transactions. And another thing to also remember is treating someone differently also applies to their association with a protected category. What that means is if my wife is disabled, that's my association to a protected category. So again, the main thing to remember is it's more than just sale and rental, and that it involves a varied different protected categories across the board, including some association to a protected category. What are the laws? There's the Fair Housing Act and the North Dakota Housing Discrimination Act, the state law. So the state law resembles the Fair Housing Act. They are very similar. We are substantially equivalent laws. Therefore, we investigate cases within the state rather than both agencies. When I say both agencies, HUD, doing two separate investigations. So if we're investigating it here, it's also filed, generally dual filed. Now, the North Dakota Housing Discrimination Act does have some of its own protected categories. Receipt of public assistance is the most common one that we see for state only. That just means being in receipt of any public assistance. Somebody could file with us based on them being in receipt of public assistance, and we would look into it. Generally, you're looking at terms and conditions or failure to rent in those instances where somebody says, you know, because of my public assistance, I was not able to live here. Those involve those sorts of cases, but they are very, very similar laws, of course, with a few key differences. So who or what is covered? Is the aggrieved person a member of a protected category? We'll go over the protected categories under the Fair Housing Act in the state there, but as I mentioned, the state has a few more protected categories. But does the main thing we assess is, does the complainant fall under one of the protected categories? If they do at intake, most likely a charge or a complaint would be filed. The dwelling is a structure occupied or designed or intended for occupancy as a residency by one or more families, or a vacant land offered for sale or lease for construction or location of a structure as a residence. So again, it's more than just apartments. It's more than just homes. It can involve rental or transactions related to land, to build, construction, all those sorts of things. And is the respondent covered under the law? There are a number of exemptions or exceptions from the law. The main one that we always point out is Miss Murphy. It's a type of law or law theory that applies to the person living there and having so many units, and again, living there. There are, of course, also religious organizations that are exempt and housing from elderly that are exempt. However, even if the housing is exempt, the discriminatory advertisements may also apply. So again, something we'll go into later with publications. But generally speaking, we're looking at, is the person a member of a protected category? Is it a dwelling? And is it covered under the law? I would say the vast majority of respondents are covered under the law, but every so often an exemption does arise. So protected categories under the Fair Housing Act, this is the federal one. You have race, color, religion, sex, participation in protected activity. The big thing to know about that is that's what we term retaliation. Retaliation means that the person participated in, an investigation, opposed discrimination, exercised a right to them under the Fair Housing Act. The Fair Housing Act prohibits housing providers from discriminating against applicants or residents because of their membership in a protected activity. So that would be, if somebody requested a reasonable accommodation, they also have participated in a protected activity, so you can't retaliate against them for exercising that right. National origin, familial status, and disability. State law, it's going to have all those with the receipt of public assistance, age, marital status, and certain victims of domestic violence. Now, North Dakota does have age, meaning 40 years or older. Familial status means the presence of children under the age of 18, being pregnant, or working to secure the custody of a minor. The big thing to point out here is, again, just because somebody doesn't appear in a protected category, you don't want to give a preference to a protected category, and we'll go over that in the publication section later on in the training. The big law update, and again, I did this last time I did a presentation like this, is the Bostock opinion from the Supreme Court. So sexual orientation and gender identification are protected under the sex provisions of federal and state laws. It's the department opinion. The Bostock definition of sex may and should be applied to the North Dakota Human Rights Act as amended and the Housing Discrimination Act as amended. So about 2 years ago, the department began accepting and investigating complaints of discrimination based on sexual orientation and gender identity in all human rights laws the department enforces. That includes housing, credit transactions, public accommodations. We have updated most of our materials at this point. We haven't seen a ton of filings on this since we've changed, but again, we have updated the materials, and I'm sure as more of that information gets out that is a protected category now, we would see an uptick eventually. And then in February 2021, Commissioner Thunder signed a memorandum of understanding with the federal department, which is HUD, saying that, yes, that is how we view things, that sexual orientation and gender identification do fall under the protected category of sex. So as I mentioned, one of the main issues, not only here in North Dakota, but across the nation, is disability discrimination. So as we were talking about the protected categories, the definition of disability is generally the first question we get. What is a disability? What qualifies somebody as being disabled? So the definition is an individual who is physically or mentally impaired that substantially limits a major life activity, or has a record or a history of such impairment, or is regarded as an individual with such an impairment. So difference here in housing versus employment is that in employment, there's the ADA. The North Dakota Human Rights Act and the Fair Housing Act did not take into account the ADA amendments and changes over various times. So there are differences, of course, between employment and housing discrimination, but that is a big one to always remember, is that there's a little bit of a difference there. Generally, it's what qualifies somebody as being a person with a disability. We do look at mitigating measures that the person has, whether that alleviates their symptoms of a disability, but also keep in mind that association is always a protected class as well. So they could be associated, as I used the example earlier, my wife has a disability, therefore I would file under associated with a person with a disability. The key thing here is to remember that if somebody presents themselves as a person with a disability, and what I mean by present is if they're in a wheelchair, the disability is obvious to the landlord or the renter, the person giving the tour, those people automatically, you're going to know they're a person with a disability. So if they request a reasonable accommodation, you don't get a look into certain things that you might when the disability is not obvious. So again, you need to know that there's a couple different factors here. The main thing is where to look at for the definition of disability, and you're going to look at the North Dakota Human Rights Act and the Fair Housing Act, not the ADA. And that if it's obvious, you automatically go into it with the assumption that that person is a person with a disability. That doesn't mean you can treat them differently, but just be aware that if the accommodation request comes up, which we'll talk about, and they are obviously disabled, there's a few steps that are different versus when it's not obvious. So it can be only discrimination if the person has a disability. No, right? I talked about association with the disability. It can be, various different things with association. Maybe their child is in a wheelchair and the landlord doesn't want that person there. Also, disability is a broad spectrum. Not everything is obvious. So, it's going to include a vast group of people, which is also one of the reasons why it is one of our most common issues and the most common issue across kind of the board here. So that leads us into common issues. Publications. So this is kind of a North Dakota important thing for us that we always point out, because there's specific protections in the law for publications. So a person may not make, print, or publish or affect the making, printing, or publishing of a notice, statement, or advertisement that is about the sale or rental of a dwelling, and that indicates any preference, limitation, or discrimination because of a person's membership in a protected category. The big thing to remember here is always describe the property, not your preferred tenant. Describe the property, not the tenant. So if you have a 1-bedroom apartment, describe that property, not who you want to live there. And I'll go over some of those terms later on. But again, you want to describe the property. So some examples of publication is anything published in a newspaper or other media, emails, written statements, verbal or nonverbal, those are all going to be publications. Discussing terms and conditions of rental will also qualify as somebody applying to rent generally. So, if
we lose you, Mike? I think he got disconnected, so we'll give it a couple minutes and see if we can get him back up and presenting again. So hold tight.
I am
There
back.
he is.
The joys of technology, I can say that the department has experienced over the last few years. Sometimes technology breaks, and that's what happens. So I left off talking about, advertising, I mentioned applications, brochures, signs, banners, email communications about a property. Those are all things to keep in mind. So I'm going to go back to sharing my screen here. And everyone can see my emails. There we go. Okay. So back to the presentation. Okay, so who is liable? Advertising media, advertising agencies. Those include, advertisement you see on Zillow and things like that. You always have to be aware of what you're posting on there. All other persons who use advertising, again, to talk about financing of a dwelling, any rental, all those sorts of things. So what happens here is we end up talking about the reasonable person standard when we're looking at what was said in the discriminatory advertising. Reasonable person is...
We're not able to see your screen.
Oh, it disappeared again. Okay.
You love technology when it works, right?
Yeah. All right, here. Let's see here. Okay, is it sharing now?
Yep, we're on reasonable person standard slide.
All right, let's hope no more technology issues. So reasonable person standard is what we're going to use when looking at this. That's just basically going to say that when the ordinary reader of that advertisement sees it, would they have noticed preference to who's living there? So the big thing to remember or avoid is some key terms, adult, bachelor, couple, family. No children is generally one that crops up. Making those sorts of statements, no children allowed here. These are single family apartments. We want things quiet because we don't want children running around, all those sorts of things. Again, you're describing who you want to live there, not the property itself. So please keep that in mind. Some other ones is the membership, approval, mentally ill, religious, nearby religious landmarks could possibly be an issue, talking about race, senior discount even, because you remember North Dakota does have age as a protected category. Now, of course, there are exemptions for actual senior or elderly living, but again, be careful what words you choose. So go by the general rule of when advertising, describe the property, not the person. So exemptions, religious organizations, private clubs, housing for elderly. Miss Murphy again comes in here with 4 or fewer units and the owner lives in one of those units. The owner would, in the investigation, have to be proven to live there. What that means is you're going to have, if you are renting the property, you will have to prove that you are living there. Private clubs, sometimes advertisements for the sale or rental owned by private clubs, not open to the public, may express preferences for a club member if the membership is not restricted because of race, color, or national origin. So again, there are exemptions here, but what I would say is generally if you're advertising for an apartment, those exemptions are generally not necessarily met. I do believe the administrative code for elderly or housing of older persons is 4605 number 1, I think it starts. And that has what qualifies something as housing for an older person. So now we want to go into reasonable accommodation. This is a very common issue. Like I said, Kirsten had given some presentation on some of these issues. Fair housing laws require reasonable accommodations for individuals with a disability. Failure to do so, failure to accommodate that reasonable accommodation does constitute discrimination on the basis of disability. The big thing to remember is There is no formal, words that have to say, like, I am requesting a reasonable accommodation. It does not have to be in writing. So you do need to try and train anyone that interacts with tenants, the public, to understand how a reasonable accommodation may sound. There are, of course, testers that do come around every so often on the national level, as well as here in the state, that do test to see what is happening in the, at apartment complexes, everything like that. So what is reasonable? Does not constitute an undue hardship or interfere with business operations. And this is closely and carefully looked at in every case. It is a case-by-case basis. It is not a hard standard that is clearly defined. If you're going to claim it's an undue hardship, you're going to have to back that up. Or if it interferes with a business operation, again, you're going to have to back that up. It's, again, a case-by-case basis. There also may be times when there are multiple accommodations in the same request. So somebody could be requesting a change to a policy that also could be a modification. It could be a request for a policy change for animals, is generally a common one, emotional support animals or service animals. It could be multiple requests in the same interaction. What you do need to do is engage in the interactive process and try to work with the tenant or applicant to get to an accommodation. Now, not every accommodation can be granted. There are, of course, some things that just can't be granted. What I would say, though, is you still try to engage in the interactive process and train and work with people interacting with the public to understand that, look, there is no magic words here. This can be something as simple as a tenant saying they can't take out the garbage due to possibly diabetes in their legs or complications of diabetes, and therefore they can't reach the common trash can outside the property. So you may have to provide them something closer or a way for them to get it down there, whether it's leave it by the elevator or leave it outside their door and then the maintenance people come collect it, or the owner of the property comes and collects it. Has to be out by a certain time. All those sorts of things could, of course, be a reasonable accommodation, but they could also be modifications. So don't necessarily see these as at odds with each other. Oftentimes they will go together. A simple one would be if a tenant is in a wheelchair and can't easily pass or transverse through the apartment and they want to put down tile flooring, so that way it's easier for the wheelchair to go through the apartment. But you as the landlord have a policy to not provide changes to flooring and things like that. Well, that would be a reasonable accommodation and a modification. But what distinguishes them is that a modification is a change to the unit generally. So widening of doors to make room for wheelchairs, adding a ramp, grab bars, lowering kitchen cabinets to make height suitable for a person, altering a walkway or provide access to a common area. All those sorts of things are going to be reasonable accommodations. So again, the big thing is to remember, although they can sometimes be portrayed as verses, sometimes they do go together, as with my example of changing the flooring. And remember that requests for either need not be in writing or use magic words. There is no magic words for what is a reasonable accommodation, what is a modification. The differences are modifications generally relate to removal of a physical barrier. The costs are generally paid by the tenant unless it's a 504 program. Reasonable accommodations, generally the cost is paid by the landlord. and it's a change to a rule, policy, practice, or service. The way I was trained in Nebraska was to look at it as, policies are easily changed. There's very little cost. Therefore, you can generally see those as reasonable accommodations. Not always, but that's kind of a good rule of thumb to go by. So I did mention the 504 of the Rehabilitation Act applies in any situation in which the landlord receives financial assistance from any federal department or agency. Take step as needed to ensure that existing housing programs are readily accessible and usable by persons with disabilities. That's going to be a general rule of thumb. Ensure that any new construction as well as substantial alterations of housing are readily accessible and usable by persons with a disability. These 504 claims are investigated by HUD, not by the North Dakota Department of Labor and Human Rights. So again, that is kind of the big distinction there. And then one thing we always want to point out is, can a landlord ask for documentation? When we refer to documentation, we're asking generally about the disability. A housing provider may not ordinarily inquire as to the nature or severity of the individual's disability. You're not a doctor is what we're generally going to say. If you're not a doctor, you don't need to inquire into the severity of the disability. However, in response to a request for a reasonable modification or accommodation, a housing provider may request reliable related information from a medical provider. Generally, those are going to show that the person is a person with a disability under the Fair Housing Act or the North Dakota Human Rights Act. It's going to describe what's required and show a nexus or a connection there. You do not need medical records or detailed information, again, about the nature of the person's disability. You're not a doctor. Do not try and make that call. Providers' requests for documentation should seek only the information that is necessary to evaluate if the accommodation or modification is needed because of the disability. So again, there's no magic words here that you should request and when not to request. What I can say is train your managers, people interacting with the public, work with the people that you employ, so that way they have training. This, of course, is a good way to do that. Anytime that something comes in, and you think it may be an accommodation request, work with the tenant also, document things along the way and try to engage in the interactive process, which is, again, working with the tenant. If you're not sure, requesting something, again, not to necessarily the severity of the disability, but what the connection is. So are background checks legal? This is a common one. North Dakota, it is legal for housing provider to ask questions about an applicant's background or to require a background check. However, at any time a housing provider makes a decision based on an applicant's background information, the housing provider still must comply with state and federal discrimination laws. What that means is, if it's asked of someone, it needs to be asked to the whole group of applicants. Do not select questions in a background check and only give them to a certain applicant. That can lead you to what we would call, disparate treatment, which is treating a particular individual differently in how you deal with the criminal background check because of he or she's or theirs protected category. An example here, and the most basic one, is you ask a Hispanic applicant for a background check, but you don't ask the same of a Caucasian applicant. That would be disparate treatment. Again, if it's going to be your process to request a criminal background check, please, again, make sure you're requesting it of everyone there. Now, there's also disparate impact. This is going to be just questions that will exclude a protected class of people. A housing provider's decision-making or selection process is neutral on the face, but has an adverse impact on the protected class under state or federal law. those are generally going to be looking for certain kinds of violations that would be directed towards a particular group of people. And again, the big thing is, if you're going to do a criminal background check, make sure it's across the board, the same criminal background check. Make sure you're asking things that are pertinent and not changing or, creating new questions for different applicants. So HUD has some recommendations here. Best practices are to deeply narrow tailored written policy and procedure for screening applicants for criminal conduct. The policy should determine the specific offenses that may demonstrate unfitness for housing, and to record the justification for policies, procedures, and exclusions, including a record of consultations and research considered. Generally, if this happens in an investigation, we're going to ask for, what is your policy and practice? Please provide us, other individuals that failed to meet this. What was their protected categories to the best of your knowledge? So again, that's why having a record and a justification is very important here. In addition to that is train managers and decision makers on how to implement the policy and procedures. Training is always going to be your first line of kind of defense. Train your staff, especially those handling applications and interaction with the public. So housing providers consideration, document the housing decisions on and basis for disqualification. Is it done internally? Know if they're doing it externally. If you outsource this, what the basis for disqualification for the person or the provider, the third party is. Are you logging the results of the review? That's an important question. Establish a formal means for individualized assessment. Clearly state adherence to fair housing laws and policy and practices against discrimination. Always maintain documentation and be consistent. We're always going to request it in an investigation, so please always keep a hold of it. Please try not to let documentation disappear, be misplaced. Those are generally going to be questions asked in an investigation. What's your standard operating procedure? Okay, you get an application. What do you do next? Okay, you refer it to the third party that does the screening. What are the steps after that? So again, maintain documentation of each step and be consistent. Establish formal means so that you are making consistent decisions. As I kind of mentioned, all this plays into the role of the department. We conduct a fair, impartial, and thorough investigation into the facts and circumstances of the complaint. What that means is, if we get a complaint, we're going to do witness interviews, we're going to request documentation, we're going to collect facts, and we're trying to answer a question is there reasonable cause to believe that the respondent committed an unlawful act of housing discrimination? So again, documentation is going to be very important to every investigation. Generally, we're going to get always an application or email communications about rental or inquiring about rental. We are impartial. We do not take sides. We listen and we look at the evidence. Determinations do come in writing, and they are department decisions. We staff the case at the department. The human rights director reviews it. If we need to consult with the Attorney General's office, we do so. And again, it is a department decision. These are not, if I'm your investigator, we work closely with each other. We're not flying off the handle or doing something rogue. We do work as a team here at the department because we are a small department. If we are also the investigator in housing, we are also the conciliator. So oftentimes this gets confusing to people when they hear that, we're also the conciliator for the case. We do have, to try to see if we can't resolve the matter informally between the parties. The investigator also works as the conciliator or the mediator, I guess, if you want to use that word, to try and resolve the matter. The thing to remember is it's confidential. You as a landlord or a charging party or complainant do have a right to representation if you so want. It is voluntary. We can't force anyone to agree to anything. But if you do, those agreements are binding. So every investigation, the investigator is going to ask, generally at the beginning, is there something that would see the matter resolved for either the respondent or the complainant? And then we pass the offers back and forth. We do not suggest monetary terms or what may be settlement, what's not settlement. We don't do that. We can suggest remedies for the public interest that is required in our settlements. What I mean by that is public interest is attending training, giving a brochure, changing a policy, creating a reasonable accommodation policy, all those sorts of things we can suggest. The big thing to remember, it is confidential and voluntary in nature. You do not have to settle. And even if you do settle, it does not mean that it is an admittance of guilt. There is no admittance of guilt in settling. It's just going to be asked if there's an interest between parties multiple times through an investigation. There's usually a last ditch attempt to try and settle. And again, we do this in every investigation. It's no different. Sometimes it works, sometimes it doesn't. Like I said, we'll investigate everything that comes forward to us. So if settling doesn't work, we're looking at determining cause. It's based on all facts and evidence discovered in the investigation. If there's reasonable cause, we issue a charge. No reasonable cause, we dismiss the complaint. There is no internal appeals process. A charge is different than the complaint you would receive. It's a short and plain statement of facts on which the department issued its reasonable cause finding. So it is different. And it's kind of the formal conclusion to the investigation. Again, if it's no cause, that's the end of the department's involvement, and we dismiss the complaint at that point. What to do? Get educated. There are a ton of resources out there. Visit our website, visit with an attorney that's knowledgeable. Document. I cannot stress this enough. Take time to think through and evaluate the request prior to jumping straight to a conclusion. Train your staff. Again, as I've mentioned repeatedly, especially those that are dealing with the public. If you don't know the law, contact an attorney. The department cannot provide you legal representation. We cannot also provide you legal guidance, but we can explain how an investigation works, how we look at things, what may or not be required. So again, be consistent, have a policy, have a practice, and be consistent. So what it means for you is to, again, there are laws out there. We have jurisdiction over the Fair Housing Act here in North Dakota. And please remember that, again, if you're interacting with the public, if you're offering rental, sale of a property, the fair housing laws do apply, and that you should always, again, train, review things. We do try and update our website with any updated information, especially regarding legal changes along the way. So, questions? And again, I apologize for technology not working.
Does anybody have any questions? There was a comment. I had one landlord that did not want the client to move in until she had furniture and she was homeless. That was not in the fair housing categories, but I also know you can't do that.
I guess, was that a question or
I think it's more of a statement
Okay.
comment.
Okay.
Unless you have anything to provide on that.
What I would say is, again, be consistent in the policy and practice. Don't give a preference. Receipt of public assistance is a protected category in North Dakota, so also be aware of that. And again, have a policy. If there's any questions, reach out to an attorney. I'm sure they'll be happy to provide you legal guidance. Anything else?
Does anybody have any questions? There was one, just, is there any way we can get a copy of the PowerPoint?
I can see what I can do on that. Generally, I can see what we can do. Most of this information is in our brochures. We do try and match our brochures to what we present on, but I can reach out to Kylie and see what I can do, what the department can do in providing either the slides or some sort of documentation of it.
Oh, there's a question. How should one handle people looking? Let me read this quick.
It's all right.
How should one handle people looking saying they have rent help?
Well, rent help generally would most likely be receipt of public assistance. So, if they say they have it, please keep in mind, again, that receipt of public assistance is a protected category. And as a landlord, you may not, discriminate in a preference of people living at your property, which again, receipt of public assistance is a protected category. So if you're advertising, please keep that in mind. There are North Dakota cases that establish, those sorts of things that have gone up to the North Dakota Supreme Court. So it's always good to check with an attorney. Always good to check our website and our brochures.
If a person has a house that they are looking to rent out and an individual in a wheelchair wants to rent it, is the landlord obligated to build a ramp or other accommodations for the potential renter?
Well, that would be a modification. And again, modifications are paid for by the tenant. But there are design and construction laws, and there is a difference between the federal law and the state law. What I would say is, again, you're going to have to check the ADAG standards and see if there's safe harbors. There's a lot of things that go into that. But again, if the big thing we see in those general cases are people advertising like not accessible, well, that's going to limit your applicant pool, and that would be a preference. So you may have to make modifications, but again, you're going to have to consult with an attorney on that.
A reasonable accommodation in one case is the installation of a bidet. Who pays for the installation?
Well, that would, if it's a modification and it's not a 504 property, it's going to be the tenant that generally bears the cost of the installation of the, whatever it may be, grab bar, lowering the cabinets, those sorts of things. I guess a bidet could be one of them.
All right, well, I think that, is rent help moving along quicker than before? I don't know.
I
know anything about that?
I don't. The department really only sees those things when they come filed in a complaint, I think. And again, I do not hold me to this, but I think it's Department of Human Services, I think, that oversees rent help. But
Yep, that's
um,
correct.
so you're going to have to speak to them. They'll be able to provide you a way better answer than I can, because we only see it when somebody files with us.
All right, well, that seems to be the end of the questions. Thank you again so much, Mike, for taking time out of your schedule to present and being able to reschedule. Those of you that are still on, please, if you need a certificate, please type your first name, last name, and email in the chat box, and we'll get a certificate out to you. I will leave the chat up for a couple more minutes, so if you haven't done so already, get that information in there, please. Thanks again for everybody attending, and thanks again, Mike, for presenting. Next week, we have Section 8 vouchers with Cass County Housing Authority presenting. So hope to see you all then.
Thank you, Kylie. And thanks again, everyone, for putting up with technology issues.
Yes, thank you.